If you pay attention to the popular criticism, the West Virginia Supreme Court of Appeals is the source of all that's wrong in West Virginia. I'm Dan Ringer, and I'll talk with Supreme Court Chief Justice Brent Benjamin right now on The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar and the Monongalia County Bar Association.
For the past several years, the West Virginia Supreme Court of Appeals has been in the limelight, and no one has been more center stage than my guest, the Honorable Chief Justice Brent D. Benjamin. Chief Justice Benjamin, thank you for coming and seeing us.
It's my pleasure.
There seems to be a lot of suspicion surrounding not only our Supreme Court and sometimes you, but the entire justice system. In fact, there was a survey taken by the ABA a few years ago that said that most people think we have the finest justice system in the world, but most people think we ought to tear it down and start all over again. You're right in the center of all this. What are you doing about it?
Well, I think certainly there's a lot of mystery to the justice system, and I do think it's something that we as justices, we as judges probably need to get out and talk to people more about what the justice system is about, because I think the first and fundamental problem is, how do you define justice? And if we define justice according to some business agenda or some union agenda or some political agenda or some agenda that's held by this media outlet or that media outlet, well, then the judges can never win, because the judges are tasked with following the law. If we define justice as application of law to facts, that's what we do, but a lot of times there's a misperception about that. And certainly, it's like refereeing a football game. The losing side generally doesn't have a really good view of what happened. And so frequently what happens is, I think, it's easy to criticize the judicial system, when in reality, the people should be criticizing the law. It's also easy to criticize the judicial system because judges don't fight back. Ethically,
well, you're not allowed to.
We're not allowed to. And so it's easy to attack a judge who can't fight back and who has no one to fight back on their behalf. And if only half the story is told, whether it's by a former litigant or it's by someone with a political agenda, that becomes problematic. And I think that's wherein politics can be the worst thing that happens.
So many people say, well, I want to be what's usually labeled a strict constructionist of whatever document it is. If on a federal level, we talk about the U.S. Constitution. On a religious level, we talk about our particular holy book, whether you're Christian or Jewish or whatever you happen to be.
Right.
But you can't be a strict constructionist because times change, things evolve.
Well, the law is more than the Constitution. The law is also statutory law, which is done by our policymakers, being the legislator and the governor. And there is a process there by which public policy is created. If we create public policy in the judiciary, especially at the Supreme Court where there's 5 individuals, in essence we're creating public policy on a vote of a majority of 3 behind closed doors. That's not the way it should be. The way it should be is as it is done in Charleston right now, here, or in Washington, where you have legislators meeting in public, discussing the public's business. It's our job then to apply the law. And when we apply the law, there's a reason why it's important for us to be stable and predictable in how we do that, because in essence, the judiciary is the backbone of government. We are the foundation of government. And if we have something more than a stable and predictable judiciary that's applying the law in the same way, case to case to case, then we create an unstable foundation for the state to grow on. And that's something that we should stay away from. So now, strict constructionism, there are judges who talk about that. There's not many that I know who do it. On the other hand, the flip side of that is the danger of the judge who comes in and says, I have a political agenda that I'm going to run from the court, and that's the activism side. And that can be very detrimental to a state.
And it doesn't have to be a purely political agenda. It can be a social agenda.
It could be a social agenda.
Independent of a
It could be a religious
political
agenda.
Yes.
It could be a labor management agenda. It could be any of those agendas by which somebody's defining justice in terms other than by law.
Well, you talked about constitutions and statutes made by the legislature, but there's a third area of law that you do make.
The common law.
Right.
And there it's important, I think, that judges have to follow strict rules of construction. There comes the time to apply sometimes facts to a given legal situation that never came up in the statutes, and sometimes we have to look at that, and we create the statute, or we create common law. But that should be done in very small baby steps. You should never make big jumps in the law through common law, because that creates an instability in the system. Unfortunately, there are those out there who want the law to develop their way, various special interest groups, and they would love nothing more than the judges to decide it their way, to call it for the home team, so to speak. And that's what we as judges have to stay away from. Now, what that does, though, sometimes is open us up to criticisms from those groups who can marshal any number of resources against us, and again, we can't defend ourselves. So unless we have people in the press showing the other side, it can sometimes be hard on us.
Speaking of being hard on you, is the press, and that includes what we're doing here and what's in print media, is it fair and objective?
I think the press serves a very important purpose. I mean, there's a reason why we have the First Amendment. The press is a necessary means by which the public gets information.
First Amendment is freedom of the press for those of you who are constitutionally challenged.
It's actually more than that. It's also assembly and religion.
There's more to it, yes.
Yeah. And assembly is important too, because that's the political side of things. But the freedom of the press is, of course, very important. And I think that just as with any other thing, you've got the system works wonderfully when you have a very responsible, very, very hardworking press who takes their job very seriously. And there are so many of those people out there, and I'm sure I'm not telling you anything you don't know. They don't get compensated perhaps as well as they should in our system, but that's a job, and it's a very noble job, just like being a good lawyer, being a good judge, being a good politician. I think sometimes it's easy to think that all politicians are bad, and most of them are very dedicated, very hardworking. This system works well. Is there an abuse of the press? Well, there may be on some of the fringe areas, but I think most of the time the press works as hard as it can to get the job done. And its job is not necessarily to agree with people in the public eye. Its job is to sometimes be critical and sometimes be the source for the public who asks tough questions. And that doesn't make it always easy when you're serving the public. But that's just part of our system, and it's a system that is the envy of all the other countries. You know, a publicly elected judiciary like we have here in West Virginia only occurs in democracies. It only occurs. It never has occurred in the history of man in a totalitarian regime, and it never will.
Well, we talk about a publicly elected judiciary, but there is, I want to say, a move afoot, but it is a trend. It's being considered everywhere, not just West Virginia.
Sure.
A move afoot to re-examine the way we select our judges and our justices,
right,
to see if popular election is really the best way to go. You want to talk about that?
Absolutely. First, I think there's this assumption that public elections are somehow bad for something. I can't get myself wrapped around that argument, because I think taking the people out of the equation for a branch of government that is tasked with serving the people just doesn't make a lot of sense from a logic standpoint. But when you look at the arguments that are out there, some of the arguments go along the lines of our founding fathers, or our founders, looked at various systems. They came up with an appointment system, and therefore we should follow that. The problem with that argument is actually a couple things. One, they never considered public elections because they were coming out of a totalitarian regime. They had no frame of reference for public elections. Number two, they didn't have the practical ability to do that. We didn't publicly elect senators under that. We didn't start publicly electing senators until much later. It took a year to do a census in a state. Imagine how long it would take to do elections statewide.
But we did have popular elections.
We did, but they weren't necessarily at the statewide level in many cases, in many states back then. They weren't, we still don't publicly elect the President of the United States. So number one. Number two, if we followed the system that the founders put in effect, then all the women in the country would still be waiting to vote in their first election.
In fact, it'd still be property.
Well, so just because the founders looked at it, the founders actually looked at 7 different systems, none of which were public elections. Public elections came in during the Jacksonian Revolution, so to speak, in the 1820s and 30s, when the thought came, if the judges are there to, in essence, be there for the people and to protect the people from the excesses of the other 2 branches of government, what possible sense does it make for the other 2 branches of government to pick those defenders of the people? It doesn't, because who are they going to be serving? And one of the most important things about public elections, I think, is that if judges are going to be accountable to something other than the law, and I would argue that judges should be first and foremost accountable to the law, but if there's any suspicion that they should be accountable to anything else, well, shouldn't it be the people rather than the people who appointed them? I mean, it comes down to if it comes down to politics, it comes down to politics of the many versus politics of the few. Politics in front of the door versus politics in the back room. And it just makes sense, I think, that the public get to elect their judges.
The thing that I find interesting, and I almost said amusing, there's an element of humor in it, I suppose, is of the 2 members of the Supreme Court that I have most recently talked to directly about this, you, who were elected as a conservative, you are a Republican.
I'm not sure what conservative means.
Well, that's the perception. You're a Republican. You are the business interest. This is by reputation, by rumor.
Yeah, okay.
Yeah, you have to read the decisions that the Supreme Court writes.
You have to read those decisions.
You have to understand where anybody is coming from, and it's different in case to case to case. These are individuals with individual ideas. But the other justice I talked to was former Justice Larry Starcher, who was a liberal justice, who was on the left, who was a Democrat, and you both say the same thing.
Well, I think we agree on that part of it. Now, former Justice Starcher believes that we should run as Democrats or Republicans. He believes that we should inject that bit of partisanship or politics into the mix. I disagree with that. I think it's fair to say that former Justice Starcher believes that the R or the D or the I or whatever you want to put after a person's name somehow gives some information to the public about where that person stands. But I think in our court what you find is that on any given case, the R or the D means nothing. In fact, I think the beautiful thing about the current court that we have is that politics is left out of the courtroom. Right now, 90% of the decisions we make are unanimous decisions. And that's with a bipartisan court that we currently have.
And actually, that's historically true, isn't it? That most of the cases, well, the 90% figure I've heard a number of times.
No, actually, it's not in our court. Getting back to former Justice Starcher, my response to Justice Starcher has been very simple. He and former Justice Spike Maynard, both had the D after their name, but there weren't 2 more disparate views on the court than Justice Maynard and Justice Starcher, even though they both had a D after their name, and the R guy was somewhere in the middle. So I'm not sure what that really means. Well,
but it is true, and in my lifetime, it goes back to Chief Justice Earl Warren on the United States Supreme Court, that no matter what your politics are, coming through the front door of the court,
right,
when you're elected or appointed or whatever the process is, when you get on the bench, in a relatively short period of time, you establish an individual identity, an individual philosophy.
I think you do, and I think this for your viewers, Chief Justice Warren was a former Republican governor of California, and when he came on the court, a lot of Republicans didn't like his views as a Chief Justice. They thought that they weren't compatible, and And my response is they shouldn't be compatible. He's not on there in a political sense. He's on there to follow the law the best way he sees.
Well, the chief politician at the time was President Eisenhower, and he declared that the appointment of Earl Warren as Chief Justice was the worst mistake he had ever made.
Actually, I think he also put Brennan in there, former Justice Brennan.
The two worst mistakes.
And it wasn't just he that did that. I think former presidents have. I think Teddy Roosevelt said that about one of his appointees. I think that's because their perception that in the appointment system, the judge who you appoint is going to always do your bidding, and the reality is they don't. Sometimes a judge, and it's easy to criticize the judge based on perception, but the transparency of our branch of government is there a written opinion, and it's what we actually write, and that tells why we decided the case in the way we decide it. And too frequently, I think, people miss that and people don't look at the actual decisions. And I can understand they're sometimes wordy and they're sometimes legalistic and so on. But I wanted to get back to the 90%. In the past, I think one of the greatest criticisms, and it has led to a lot of the criticism of the court that's caused a lot of complaints about this court or about the Supreme Court, is that the Supreme Court of West Virginia has been a group who frequently did not get along, who on the spur of the moment would say mean and nasty things about other members of the court. There was no collegiality, and some people even question whether there was a professionalism at the court. And to be honest, one of the reasons I ran was because I thought there needed to be a change at the court, that we needed to get to be a more collegial court, a court that focused more on law than on politics and law than on policy. And the 90% figure that we attained in the January term of this year, I think, is historic in West Virginia. In fact, to my knowledge, it's never been close to 90% of a court's decisions being unanimous decisions. And to put it in perspective, the United States Supreme Court, which is an appointed court, has more 5-4 to split decisions than at any time in its history, and is widely viewed as the most political court in the country, versus our elected court here, who is agreeing 90% of the time. And I think it's important for your listeners to understand, we're not deciding these cases and deciding together 5-0 because there's some magic to that. I think what the difference is now is that you don't have nitpicking going on between justices, but you have communication going on between justices, and there's more of an attempt to make a better decision that's coming out that is more reflective of a court rather than individuals on the court. And there's a lot more time that goes into writing opinions and trying to see where there is consensus rather than where there's controversy.
Well, you brought up the political aspects of the way courts decide in the United States Supreme Court and their split decisions. How do you handle the political imperative that comes with being an elected official? You were just absolutely dead center of a case that went to the United States Supreme Court saying that you shouldn't be allowed to make decisions dealing with certain people because they were close to you or they were influential in your election. And you're saying there's a judge, and
I think what the court said is there was an attempt to influence my election, and the attempt alone was sufficient.
But a conspiracy to elect an elected official, there's nothing wrong with that.
Well, I'm not sure about that, but
well, if I decide to support you and I recruit my neighbors to support you, do you owe me favors as a result of that?
Of course not. And I think you point out something very important, because there was one thing that I think a lot of people don't realize is that in that case, which involved the Massey Energy Company, that over 4 years, the U.S. Supreme Court did not consider one thing: my actual voting record. Now, as I'd said earlier, that's the transparency of our court. That tells you what a judge is actually doing, and I think most people would realize that the rubber hits the road when you look at what the person's actually done rather than what somebody says they've done.
We need to point out that in the opinions of the state Supreme Court and the United States Supreme Court also, the vote of each member of the court is recorded. You can tell who came down on which side of the case by reading the opinion. If it's a unanimous decision, you know how everybody voted, but if it's a split decision, you not only have the vote of each judge or justice recorded, they're given the opportunity to write opinions joining the majority or in opposition to what the majority said. These are called concurring and dissenting opinions.
Right.
So you have the opportunity to really document what you were thinking in a particular case.
And you can always see the judge's record. Now, of course, you have to go look at what the judge actually wrote to see why they did it. And it's easy to take judges out of context, and that's highly inappropriate for a judge who can't defend themselves. In the U.S.
And we should say that too. In the case that went to the United States Supreme Court, Caperton versus Massey,
right.
You had no voice in that case.
I not only had no voice in that case, I would have appreciated if they'd had actually my voting record, because I think rather than rely on perceptions that could be vague or could mean any number of things, the voting record, I think, was pretty compelling, and I think most reasonable people would have looked at a voting record that was actually, as I later found out, 82% against Massey over 4 years.
Well, as long as you vote in the big cases the right way.
Big cases, voting for Massey, I think, to the tune of $50 million is what they found. Voted against Massey to the tune of $350 million, which was, or $320 million. It was a substantial amount more. And unfortunately, for whatever reason, Massey did not choose to introduce that in front of the U.S. Supreme Court. So we don't know what role an actual record means in that whole case. But I think that what it does demonstrate is that we attempt to be as non-political as we can be, but at the same time, we live within a very political world, and actually the only reason we run politically is because the legislature requires us to, and they can do that by under the Constitution. It's up to the legislature could change that at any time.
What can you do? What are you doing to make the public feel better about the court system?
You know, it's a wonderful thing we've had an opportunity to do this year. It's not gotten a lot of publicity, and maybe we as a branch of government should hire publicists. We're the one branch of government that doesn't have public relations specialists. We spend the people's money on other things like courtrooms and so on. But in a year such as this, when we knew that there was some economic issues affecting our state budget, we actually reduced, at my direction, and the court agreed, we reduced our discretionary budget for the entire judicial branch. We reduced it by 11.5% for this current fiscal year. Now, to put it in perspective, the judicial branch, which is 1/3 of the government, we've got the executive branch, the legislative branch, judicial branch. We operate, even though we're 1/3 of the government, on 3% or less of the state budget. So we operate very efficiently, I think, and compared to other states, according to the National Center of State Courts, we work very, very efficiently. But even then, we reduced our discretionary budget. There are certain things we don't have control over, such as salaries and so on, that the legislature sets. But of those things we can control, we reduced it 11.5%. And notwithstanding that, we expanded court programs to the people. Now, the squeaky wheels, which often are special interests, would, of course, love us to do things in those areas, and I'm sure they would. But our job is to serve the people. This year, we've expanded drug courts. It's a program whereby nonviolent drug offenders get a chance to avoid prison time, but they have a very tough road to go in order to do that.
They live literally under a microscope.
They do. It's drug testing. They have to get jobs. They have to do community service. They have to pay taxes. They have to become self-reliant. They have to become responsible citizens. And if they do that, and if they make it through the entire system, then they can avoid prison time. Now, how does that benefit the public? Well, easy. It takes $30,000 a year to incarcerate somebody, and in many cases, drug court can take 2 years. That's $60,000. Drug court, the entire program, generally runs under $10,000, so there's a savings there, number one. Number two, these people, while they're in the program, are working. They're paying taxes. And the studies show they will continue to pay taxes afterwards, so they're not relying on the state, per se.
They're supporting the state rather than the other way around.
Exactly. And the recidivism rate when they come out of the program. When they come out of prison, national figures put the recidivism rate, the going back onto drugs rate, at somewhere between 60 and 85%. So it just means there's going to be another problem down the road. which is going to cost yet more money. But the recidivism rate, the going back to drug rate for graduates of our program is 15%. So you've got
From 85 to 15.
Imagine that. And they will continue, and the studies show they continue to work, they continue to pay taxes, and they continue to do community service. And a lot of that is reaching back, turning around, reaching back behind them, and helping pull up the people who once were like they were. And I'll tell you, it really affects you when you see a child, when you get to hold a child who's just 6 weeks old, and you realize that this child was born to a mother who was previously drug dependent. That child would have been born as a heroin-dependent baby had it not been for the volunteer efforts of judges, prosecutors, sheriffs, probation officers. This is mostly done by volunteer efforts of a lot of public servants. It's a system that works. We started off this time last year. The program was in 4 or 5 areas of the state. We now have it well over half the state. That's been an expansion of services, and I would argue that that is an area where we actually serve people. And now, as of today, we started Access to Justice, which is going to make civil access to justice better for our friends and our neighbors who can't afford lawyers.
Chief Justice Brent Benjamin, thank you, sir, for being with us.
You're welcome.
Thank you also for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening. If you want to know if you need a lawyer, you can discuss your problems with a lawyer by calling the West Virginia State Bar Helpline, toll-free, Tuesday evenings from 6 to 8 at 1-800-642-3617. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks show topics, information on how to obtain copies of the programs, and additional information about this show's topic. You'll also find a list of legal resources that can help you answer your legal questions. If you'd like to recommend this program to a friend, you'll also find video of this program on thelawworks.org. If you would like to suggest a topic for a future The Law Works show, or if you're a school teacher and would like to receive a copy of this program for classroom use, please send us an email to thelawworks@comcast.net.
The Law Works is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The Law Works is made possible by the generous support of the West Virginia State Bar and the Monongalia County Bar Association.
From West Virginia Public Broadcasting.